Okay, welcome back, guys. I have a very special guest. It is one of the first times I believe I've been on with her, certainly my first time as the host, Ann Bremner. Welcome to the show, Ann.
Well, thanks. It's a pleasure to be on with you.
Yeah, listen, guys, Ann is the real deal. She is like Gene Rossi on the East Coast, Ann Bremner out there on the West Coast. What a dynamic duo. Hopefully I compliment them as well. Ann is a former prosecutor from the great state in the Northwest, Seattle, Washington, at the King County Prosecutor's Office. She has had a prolific career as a prosecutor, as a defense lawyer, representing many high-profile clients, and is an incredibly sought-after legal analyst. And it's great to have you. Let me start with you. This Burgoyne case, this insanity defense, I was talking to Gene about this. Vermont a little different. I don't know how you folks do it out there in Seattle, but it's only a preponderance standard for the defense, which makes it much easier than the clear and convincing standard in most other places. And the interesting aspect of their law is that instead of the typical standard of knowing the difference between right or wrong, this is basically lack the capacity to appreciate the criminality of their conduct or a mental disease or defect that causes them to be unable to conform their conduct as required by law. The way I read that, Ann Bremner, is that this makes it much easier for the defense. Thoughts?
Well, absolutely. Out here in Seattle, we're preponderance, but we have McNaughton, and it's the and rather than the or. But sure, it's kind of the way a lot of us think, or lay people think about an insanity defense, which is just don't appreciate, certain aspects of things. But, when I was a prosecutor, when we had insanity cases, no matter what the standard, we used to always say, it's not like he robbed, in robbing a bank or whatever the crime is, it's not like he held up a telephone pole with a banana. I mean, that's how extreme we would usually argue it. And it's not a very popular defense here in this state. And of course, we've seen a lot of changes after John Hinckley all around the country. Talk
to me, Ann, about your thoughts on the concept that I know we're not allowed to talk about it. I know people believe it doesn't exist, but I've been around the block as a homicide prosecutor and as a criminal defense lawyer myself to know about the idea of jury nullification.
Oh my gosh.
There are 5 dead teenagers here. This guy crashed into them, got into a police car, put his seatbelt on, drove at over 100 miles an hour and re-crashed into them, caused all of this, has been described by one of the witnesses, Ann Bremner, as Armageddon, a war zone, debris everywhere, cars on fire, cars turned upside down, carnage. Will they nullify this defense?
Yeah, I mean, it's like, and the thing is, I mean, every aspect of the case just screams out horrific. And given that, it's just going to outweigh any thought of insanity. And you know what? I just think, just lay people, when you talked about the insanity defense, you ask anybody, people just don't buy it half the time.
Yeah.
It's like, you're just not that crazy. I mean, and it's an excuse, it's just something that I think that I've seen in cases that I've only seen one case out here in Washington where it worked. Where somebody killed their wife with a hatchet and tried to make it look like a car accident. I mean, it was so kind of crazy.
Gene Rossi, I'm sorry, Ann. Gene Rossi, to Ann's point, does a jury really want, in a case like this, to hear the guy holding up holding on somebody up with a banana? Like, do they want to hear crazy? Or do you find that jurors listen to the law and typically follow the judge's instructions? Will they nullify the insanity defense should they find in favor of the defense? Thoughts?
They're not going to, what they're going to do is, first off, I got to criticize Ann. She said it was great to be on with you. She didn't say you and Gene.
Oh.
Okay.
I said both of you.
But no, what it's going to do is the burden of proof is preponderance for the defense. Subconsciously, they're going to hear that, and they're going to raise that burden a little bit higher, because when you have 5 deaths, not just 1, 5. They all subconsciously know after the verdict's rendered, if they find him not guilty by reason of insanity, they got to explain that to their friends and neighbors. Well, they don't want to do that.
Yeah, Gene, I was going to ask, do you have any insights into what this community is like? I mean, obviously, this is a big impact when 5 teens are just wiped out, 5 innocent young kids doing nothing wrong. And what level of, do you think it comes into their thought process? Like, I got to go back and tell my family and my neighbors in my community. I'd imagine it's probably a small, tight, insular, close community there in Vermont. I mean, it's going to have an impact.
I'm from Connecticut, a small town of about 8,000, 7,000 people, and I think it's Crittenden County. It's a really tiny county in Vermont, and Vermont's not a heavily populated state. That populace number is a factor, and I'm not going to say they're ignoring the instructions. I'm just going to say they're going to hold that defense to the fire, and there are a lot of facts to suggest that the insanity defense in this case is just not going to fit.
Well, Gene, Ann, you want to know what's insane? Gene, that's Ann. What's insane is that if we go to break and people actually don't stay with us to see more Ann Bremner and Gene Rossi, it would literally be insane. We'll be right back. Okie doke. We are here at the Law&Crime Network. My name is Bob Bianchi, and Bourdoin's getting a little slow there with that action and reconstruction expert. So we want to do a little bit of a pivot, especially while we have a new guest, Ann Bremner, on with regard to the McStay family murder, Charles Murr. Guys, Gene Rossi, Ann, I'm being told by one of our producers here that Dan Kavanaugh cannot be found. Gene, we were talking before about a tactical move, if the prosecution could find them, to call him, knowing he'll invoke his Fifth Amendment rights so that they don't get an adverse inference charge at the end, or the defense being able to comment that they didn't call him. But that doesn't make a difference because nobody can find him. The defense has tried to. From what I understand, the defense made an argument to the judge, and the judge agreed that they will be able to advise the jury of that and discuss it in summation. So let me go to you first, Gene, since we talked about it earlier. I think this is even better than having Kavanaugh available for the defense. He's in the wind. Maybe he's on a banana boat cruising around Hawaii because he does not want to be found. No bueno for the prosecution.
And you know what else I'd ask? I'd ask the 8-ball judge for an instruction. Flight equals consciousness of guilt.
Yeah, really good point, Gene. And again, Ann, we talk about the judge had limited some of this third-party guilt, as we call it, but enough of it is bleeding into this trial. I think that this is yet another devastating blow for the prosecution. What do you think?
I agree. You know, but we used to call it the Saudi defense. Some other dude did it, S-O-D-D-I. and there had to be some train of circumstances to point to that other person for you to even get the evidence in and then to argue to the jury. So in a case like this where he can't be found, as a prosecutor, I think you just want to elicit all of the facts that shows that he didn't do it and just come out clear with the jury, because it's going to come to the jury, he can't be found. And Gene's right. Evidence of flight is evidence of guilt. That's a standard instruction. It's a stock brief in every prosecuting attorney's office.
Yeah, you know, Ann, look, I have been in the rigors of homicide investigations and running them. I understand data management issues, and there's lots of moving pieces, but we were always very careful as prosecutors to do the most important thing, is to make sure we got the right person. I mean, it's kind of basic. I'm sorry I get agitated at this. I want to know in my own mind, forget about proof beyond a reasonable doubt, I want to know that I'm not convicting a potentially innocent person. The second thing is, they didn't even go check out this alibi of Dan Kavanaugh. And this is in the face of clear information that the prosecutors had that Kavanaugh and Mr. McStay were having bad problems with one another, where Mr. McStay actually says to Kavanaugh in a text, "Now my wife and my kids know what you're all about." So one, my prosecutorial instinct, my curiosity says, I need to check this guy out big time. And it could also be a murder for hire, whether he's in Hawaii or not. Why did they not do follow-up investigation? And what are your general thoughts about the investigation in general?
Well, I think that's inexcusable. I mean, we don't know why they didn't, and we know that they should have. I mean, like you just said, I mean, a prosecutor's duty is to do complete justice, and that means you can make sure you've got the right guy or gal. I mean, period, end of story. Especially if there's evidence that somebody else could have been involved, as has been argued here. You know, I think this investigation, I hate to put a thumbs down on a prosecution, but it's been wanting in many ways, as has the prosecution itself. And I think that's evidenced by what we just talked about, which is not looking into an alibi of a person who everyone's, at least the defense, is pointing their finger at, and maybe rightly so. But the other thing is, what about things like this? Opening statement, they get up and they say they died in the house. Why do you take on a burden that you don't need to? You know, we all know as ex-prosecutors, you've got a burden, you embrace it, you go over it as a prosecutor, but don't take on burdens that you don't have to.
Well, you know what, Ann? I'm gonna do something I've never done before on TV, but this is a little bit of my acting. I'm gonna be Gene Rossi. Now I know this is difficult. He's a hard act to follow, and imitation is the sincerest form of flattery, Gene. I think Gene's answer to that would be they needed to do this because of venue, jurisdiction issues.
Yes.
I hear Gene saying yes in the background. This is how much this man is influencing me. I think of Gene Rossi in the middle of the night. But what do you think about that jurisdiction issue?
I don't know what the jurisdiction
Yeah,
issue
so
is.
in other words, they needed to show that the murder occurred there because the bodies were found all the way across the country in a desert, that they needed to show where the murder took place.
Yeah, okay. I mean, but really, I mean, they've got jurisdiction and venue. They're in the trial. So, and then they're going to have to, as an element of the crime, of course, to the jury as to where the venue, where it happened. It happened in a certain county. But I guess don't emphasize it too much. I mean, I guess take it on because you kind of have to. You can make an argument that there's preponderance of the evidence beyond a reasonable doubt. You can show that it was within that vicinity of the county. I'm just saying there's no evidence that they were dead in the house. Zero.
Yeah.
I mean,
And to your, wait, so I know Gene wants to get in here. Go ahead, Gene. It's got to be quick.
Oh, and I had a case where venue killed my case, and you got to prove it by preponderance. And the reason they had to embrace it is if they didn't have venue, they don't have a murder charge.
Well, I get that on the elements of the crime. As a young prosecutor, you'd have somebody move to dismiss because you forgot to say, did it happen in King County? I mean, that would happen to younger prosecutors in my office, so I get that. But I think that their theory of the case is not that strong. The evidence, in a lot of ways, arguably, is not that strong. It's a circumstantial case, and they're going to have to piece it together. And I think that there's just been some, in their steps forward, there's been some missteps.
But guys, let me ask you, how persuasive in front of the jury is it as a defense lawyer? I mean, I think I've got so much information to go in summation as a defense lawyer. I don't know where to begin and end. So, but how persuasive is it to say, guys, ladies and gentlemen of the jury, get this. They're in the house. They're taking pictures of things. They call the homicide detectives with dogs. But what do they not do? They do no forensics. And if 5 people are murdered inside that house, that ketchup spatter that you see on that table that they want you now to believe is the evidence of 5 people being slaughtered, give me a break. You should lose on that incompetence alone. You can't put someone in jail on this malfeasance. Is that an argument, Gene?
I think it's a great argument, absolutely. And you know, in the closing for the guilt phase, you can't mention the death penalty, but they know it's a death penalty case. And you could say, in a case of this import, when a man's life and liberty are at stake, we have to have a case that doesn't have garbage in it. The other thing I wanted to bring up real quick, Federal Rule of Evidence, I don't know what the state number is, 804, when you have a missing witness, but they make a statement against interest, I would make a motion to call the girlfriend, renew the motion to call the girlfriend and have her quote Dan Kavanaugh because he's unavailable.
Right. Okay. All excellent points. Guys, I love having you two as guests on this show. I wish we could go on and on and on, and we will, but on the other end of this break. All right, so, Ann, we're talking about failures to do certain things with regard to crime scene processing in a day and age, by the way, where people expect things by watching TV like CIS and NCIS and things of that nature. You know, as prosecutors, we have to deal with that all the time and try and explain things to a jury. But what are your thoughts about this lead investigator with regard to the failure to follow up or at least be able to talk to the jury cogently about dotting I's and crossing T's with respect to the forensic records here?
Well, it's a huge deal. I mean, it's garbage in, garbage out, and or there's no garbage. There's no evidence. We worked on the Amanda Knox case out here, at least on the media end, and that's a great example. You know, in that case, we called it Fellini forensics because of the way the evidence was mishandled, and ultimately it was found by independent experts to be compromised, contaminated, and inadmissible. It was a bra clasp and the end of a knife. That was the whole case. Because if you have something that violent, you know, occurring like in the Amanda Knox case or in this case, you're going to have all kinds of evidence. And there's nothing here. Absolutely nothing. Isn't that enough for reasonable doubt with a jury? I mean, isn't that enough? There's not even anything that they're showing that can be questioned. They simply don't have it. And so that, I think, there'll be a field day for the defense, like you appropriately said. And it's not just going to be about this, but this will be a large piece of the closing.
Yeah, Gene Rossi, Ann Bremner from the West Coast has thrown out the Fellini reference. Now, you throw out a lot of Latin and you go to the classical works, but what do you think about her Fellini-esque, if you will, analysis of how the prosecution's doing?
First off, I must be Italian, but no, Ann's right. And I just thought of this while Ann was talking. Remember when the prosecutor was cross-examining one of the defense witnesses about clothes in the bathroom? And he was saying, well, the defendant could have cleaned the bodies in the bathtub. Remember that? Could have killed them in the bathtub. There was no blood in the bathroom. So I would use that in closing. These prosecutors are stretching everything. They're even going to the bathroom where there's no blood.
Yeah, and guys, I don't think it takes a jury any level of sophistication or need for experts to know that this cannot be the result of what this massive, violent, multi-homicide cases. And I go back to an experience that I had where a murder case that I tried as a prosecutor where the victim was killed inside of a kitchen. It was just one victim. And there was blood spatter on various pieces of furniture in the kitchen and on the wall. And on an evidence review, see, this kills me. They've got a picture of it right there. And if you had done an evidence review, somebody should have said, this needs to be swabbed and tested. And that would have turned this case from a missing persons case into a potential homicide case. Because as I opined to the investigative officers in the case that I had that hadn't swabbed and submitted, you did the best ketchup spatter analysis known to mankind. Ann Bremner, thoughts?
Oh, absolutely, absolutely. I mean, and that's the other thing, like in the Amanda Knox case, they were actually cleaning up some blood splatter. They were cleaning up some bloody fingerprints. It was like, no, it's on video. But go take it out. Take the flooring out. Take that table with you. Take it to the lab.
Well,
make sure you check everything.
And to your point about that, and in my case, ironically, the person was a cleaning professional who did a very good job at trying to clean up. But nevertheless, the transfer that's going on as they're trying to clean up. And in fact, to your point, and Gene, I don't know if you've ever had a case like this. We had a homicide case when I was a baby prosecutor where a great detective, back before DNA was really, you had to go to Quantico and make a special super duper Gene Rossi request in order to get them to do any kind of processing. And a lot of times they would only do blood type. They wouldn't even do DNA. And in that one, they pulled up the floor tiles and found blood. And it was based on that we were able to get a conviction. No curiosity here, Gene.
Absolutely not. And I just had this thought. The reason they didn't test that table for blood is I bet you that first group that went in or the second group is they looked at it and they said, nope, that's not blood. It's probably grape juice. I'll guarantee it.
Yeah, but Gene, you know as well as I do, and Ann, having been around the block, they took a picture of that for a reason. They felt that there was evidential value, but did no follow-up. I honestly have never seen anything like it, Ann.
I haven't either. I mean, take the picture and like, oh, but it's just ketchup. I mean, it's just ridiculous. It's unfathomable, what they failed to do here in such a serious case.
Yeah, and I think what they're basically asking is throw it all up against the wall. If I were the defense lawyer, I'm saying, you know what they want you to do, ladies and gentlemen of the jury? They want you to do the work they didn't do. And the problem with the work that they didn't do is it would have showed you who the real killer is, the guy who they turned, hear no evil, speak no evil, see no evil, Dan Kavanaugh, who can't be found, who they've just accepted this alibi from. Give me a break. Go into that jury room, guys, and come right back and knock on that door and say not guilty. Let the state know that they cannot be this sloppy. I got Ann Bremner with me. I got Gene Rossi with me. I got great cases. I got more Law and Crime on the other end of this break.